adopted, and given the fact that most attorneys like ourselves have been working outside of our offices and our physical offices, we've adopted to this whole virtual office concept. Some of us may be very familiar with it, some of us not. Do you anticipate any actions that the state bar, the clients may or may not be able to take against attorneys being virtual? And what suggestions do you have for attorneys who are operating virtual to maintain their fiduciary responsibilities as an attorney?
Well, I can say this. Our industry and our profession, thank goodness we're able to continue operating, because a lot of people, hairdressers, people that have bakeries, a lot of people don't have any work at all. Yeah. So we had to be really nimble in changing the way we practice. Luckily, many of us already have a cloud-based system with our files, and that's great. It could be seamless moving off site, but it's not the same, that's for sure. But our obligation to maintain communications with our clients and to maintain that level of competence doesn't change, even though we're in the midst of an emergency situation. I mean, it's the new normal, as that people are talking about. Mm-hmm. Many of us have a lot of family commitments. Now, if everybody's children are now at home, they don't have any daycare. They have to be somehow juggling client needs with, needs of, getting schoolwork done. All of a sudden, if you have multiple children, you're doing 6th grade and 8th grade or whatever grades. So you're following up on all that. I know for myself, I have a high schooler and an 8th grader, and I just forward on the emails. I don't even read them, but the emails I get from all these teachers, I just tell my kids handling them. I knock on wood. I literally can't keep on top of it. So, but our duty to maintain the constant communications with our client, and it's twofold. One, we have the duty to notify the client of significant developments in their cases. And obviously, anyone that their trial dates are off, obviously we had to let them know. By now, I hope we have. And also, we have to respond to reasonable requests for status reports. So, client inquiries. So, I know one attorney I know, he was locked out of his office, like most of us were. Many of us, the office buildings closed. And because of the phone system where he rents an office, you can't forward that number. So he had to get his client list and call every single client and then text them and email them his cell phone number. So that way they would be able to reach him. And that's what is necessary. It's a lot of extra work, but you have to keep that line of communication. And it's not an excuse to say it's an emergency, because if the clients are calling, we really need to be some way to communicate with them and document those communications.
Right. And I know a lot of challenges came for those who weren't prepared or who were in high-rise buildings with no access. And I know, given that I do personal injury, so the defense firms and the adjusters, the companies, it took them a while to get adjusted, but we are thankfully up and running, and it's been great. So there was another concern that could come up with virtual offices. What do you think about the fact that you have now non-staff or the staff, which are non-attorneys, working from home, who have actually taken physical files with them to work on the case, or the fact that they have monitors in the living room while their significant other or other members of their household or friends can see their monitor?
Well, what you're hitting on is the issue of client confidentiality. It's a lot easier to maintain confidentiality of your files if you're all in one office together. It's easier to supervise your staff when you're all in one office together. But now people are far flung in their apartments or homes all over the place, working and doing the best they can through whatever internet access they have to their homes. And so we have to be really careful in maintaining the confidential information in those files. And I heard, or I saw on one of my listserv, a great idea. One attorney, she's buying her staff members these screens to put over their computer monitor so that you can't read it from the side view. It has to be directly in front of it to help shield any of that confidential information from people that might be walking by in the house. Same thing with the file. Remember, now the files are scattered. If people were still using paper files, now they're scattered, and now you have to somehow keep track of those and make sure the confidential information. A regular personal injury file contains a lot of very sensitive medical information, may have social security information, most family law file, amazingly dangerous information that we're getting out. So we lawyers have an absolute duty to maintain the confidential character of all that information. And I would say with respect to whatever electronic communications we have, like over the cloud, maintaining storage, we have to go with at least what the standard in the industry is, because we don't have to become IT experts, thank goodness. Right. But we can't be just
nonchalant about it. Yeah. So for those of you who are joining in with us today, thank you so much for taking your Thursday night and to join Erin Joyce being a guest on my program with regards to providing some guidance to attorneys. So if you're an attorney out there, this is for you. We're providing you some insight from a former state bar prosecutor with regards to tips, do's and don'ts, how to protect yourself, and what to watch out for. So Erin, with that said, I want to move on to a very hot topic that just came out recently. And I know you posted about this, and it's very exciting because we've all heard of legal match, right? So can you give us, before getting into the details of the case, what is legal match to your understanding?
Legal match describes itself as an online platform that clients can use to try to find an attorney.
Okay.
But legal match,
it engages clients, consumers, and attorneys.
Right. It's used by, it's for no cost to the consumer. They're just doing a search, and then they put, I think they have like an online form that the potential client fills out, and then legal match will send that information, and somehow they will get that information to some of their subscriber attorneys in whatever geographical area and hopefully area of practice that the client is looking for.
Okay, and on the attorney end for legal match, it's subscription based, meaning like a monthly fee or whatever their contractual terms and conditions are with joining their program and paying them in order to get these leads, correct?
Right. So basically lead generation. Yes.
Okay. So now there was this Jackson versus legal match case that you posted about. I want you to talk about briefly what the factual basis of what allegations is Mr. Jackson making against legal match, and then we'll get to the holding and what stages of procedural stages they're in.
Well, the initial case was really a collection matter. Legal match was suing this attorney Jackson for unpaid monies due to legal match because Jackson added a contract. He was one of the contracting attorneys with legal match, and obviously he must have decided it wasn't worth much. So he stopped paying them. And at the lower court level, Jackson lost and he appealed. Okay.
So basically on the lower court level, the court found that he had to owe on the contract and pay. But what kind of a concern did this raise for the State Bar of California? What's going on?
Well, what happened is Jackson appealed, and on his appeal, his claim was that legal match was operating as an unlicensed lawyer referral service. And the State Bar of California has, and under the State Bar Act, there is a statutory scheme for a registered lawyer referral service, just like is operated by the Los Angeles County Bar Association, San Fernando Valley Bar Associations, many different affinity bar associations have these lawyer referral services, and they operate with the potential client paying a small fee, then getting matched with a vetted attorney.
Okay, so Jackson obviously was not happy about the fact that he's losing and he has to pay on the contract, and so he spun it to be the fact that they're operating an unlicensed referral resource base without meeting the requirements under the California Code. However, Jackson, I'm assuming, is an attorney, correct?
He is, yes. Yeah.
So what did that raise as flags from the State Bar with regards to Jackson and other people like Jackson who have signed up to legal match as an attorney, and what concerns were they considering?
Well, what happened is on appeal, the appellate court found that legal match could not collect the fee from Jackson because they were in fact operating this unlicensed lawyer referral service. So legal match and several amicus were filed to get cert for the Supreme Court, and the California Supreme Court denied cert. That happened, I think earlier this year. Okay. And so this week, the State Bar of California brought a temporary restraining order against legal match, claiming we're running this this unregistered lawyer referral service.
So essentially, the temporary restraining order was just to stop legal match from operating until the decision comes down, or a decision comes down?
California at all, saying basically that they cannot operate in California. And that was filed in San Francisco Superior Court. And I think just today I saw a headline, and I looked at the part of the article that was in San Francisco Superior Court, and the request for a temporary restraining order was denied.
Okay, so that means what? That means legal match can still continue to operate.
Well, at least there's going to be no temporary restraining order.
Right.
Litigation. And one of the facts that came out from that story is that right now, as a result of the Jackson versus Legal Match case, Legal Match has filed a application to become a registered lawyer referral service in California. So even though that application is pending, the State Bar still took that action. And I could say, having read the temporary restraining, the request for a temporary restraining order, part of what the State Bar said is that all the lawyers in California that are participating with these legal match contracts are getting illegal referrals from legal match. So basically, a specter of prosecution by the State Bar for having a contract with legal match.
So, but is there privy with the State Bar coming after these legal match attorneys who may or may have not known what legal match's practices were? I mean, do you anticipate any defenses with that said?
Well, I haven't seen that kind of case coming down, but the fact is that, especially reading the papers from the Office of General Counsel, sounds like that they had some idea that would be a successful strategy to push toward that type of prosecution. I would say, now this is the thing, legal match is not capping. The capping is illegal in California.
Correct.
And there's a very big difference between a lawyer who's knowingly engaging with a capper versus a lawyer who has a contractual relationship with legal match. I mean, that seems to be very obvious, but maybe not so much by the State Bar. That's what I would say.
So that just raises a lot of questions in my head for, we're always out there hungry, looking for cases, joining programs, whatnot. Do we as attorneys, even, whether you were starting off or we've been in the practice for several decades, do we have the duty to go beyond the sales rep of, let's say, legal match and say, listen, what are your practices? Are you registered with the State Bar of California? Do you know, the laws and the requirements? Like, what are we supposed to do?
This is the thing. It's not a done deal with respect to whether or not the statutory scheme for registered lawyer referral services even passes muster under the Constitution and the First Amendment.
Okay.
So that type of statutory scheme was developed at the same time, or so long ago, it was the time before this, any lawyer was even allowed to advertise in the state of California and in most of the country. There are still states in the country where you cannot use a trade name and practice law. And that's under attack in, I think, 11 jurisdictions right now under the First Amendment. So I see, and it's not my case, but I see a potential First Amendment defense to this lawsuit filed against legal match by the State Bar.
So, Erin, we have a question. Actually, Carolyn Shining is saying, so the State Bar is going to start seeking out lawyers with legal match?
If you read the papers that were filed in support of the temporary restraining order, there is language that looks exactly like that lawyers that are actively seeking referrals from legal match are engaging in they're getting illegal referrals.
So however it comes down, we're not sure, but it's going to be very interesting. And I'm sure, Erin, you're going to post stuff on it. Now, with regards to any final thoughts on the legal match, because I wanted to move on to the state of emergency.
I just say you never know. Just because it might make sense to you or make sense to me does not mean that the State Bar will take that course. Like I said, They tried and unsuccessfully tried to prosecute attorneys that were Chapter 13 bankruptcy attorneys for violating a state statute for collecting fees in fees, which had been blessed by a federal judge.
Wow.
Yes.
Interesting. Okay, now we're in a state of emergency and we don't know when it will be lifted or what will happen. And we know that it has caused a lot of pushback and closures on in the court systems and a lot of stuff. So I kind of want to take it into a two-part step. The first part I want us to discuss is the fact of meeting client expectations and versus desperations. And then the second part I want to get into is the statute of limitations. But going to my first question, clients and attorneys are, we're all in a bundle, and whatever state of emergency we're in, it's affecting us to whatever level or to the extent it could be. As a personal injury attorney myself, I have a lot of pressure, I feel like, from clients to settle cases. However, on one hand, I also feel like that I can build up the case, or the case's value is not what it's worth, what the client wants me to settle. So I'm just bringing an example. This is not currently happening, but as a personal injury attorney, I can relate to that. I want to know what advice or what we should tell our attorneys with regards to clients kind of forcing our hand or using the COVID-19 as leverage to settle cases.
This is what I would say. The client comes to the attorney for the expertise of the attorney. That's not to say clients listen all the time. In fact, most clients listen poorly. I mean, I don't know. I'm sorry. Even attorney clients listen poorly. It's just a fact, because guess who owns the case? The client. And if the client wants to, run their case right off the edge of the cliff, I just don't need to follow them over.
True.
Hey, the cliff is coming. You really want to go there? I really don't want to follow you, and I'm not going to. I mean, that's for sure.
Okay.
Documenting all of that. So I think it's really important, and that's where we're here to be an advocate. We're both counselor and advocate, counselor at law, advocate. Part of that counselor part is really trying to give the client all of the information, because they're panicked. They're not, thinking clearly. They're not the professional. And really, it's always going to be, holding the bag, the attorney. So we have to make sure, eyes wide open, if quote, they're forcing the settlement. They're like, I need to get this settled now. We should give them whatever options there could be. Maybe there's a potential for and I'm not saying this is a great idea, but this is a possible idea, litigation funding. If that case warrants it and it can get them through more months, maybe that's something to consider. I, as an attorney, probably would say not a good idea to suggest any particular litigation funding company, because I don't want to be responsible for whatever is, there's multiple ones out there.
Right. There.
Search and get one. I personally don't think it's a great idea for a lawyer to be having any relationship with the, at all, with the litigation funding company. And they're very expensive. And I would let the client know that's an expensive course, but probably less expensive than you completely settling your case at 40 cents on the dollar or whatever it would be.
So let me bring an example, Erin. Let's say we have an offer on the table of $5,000 and we think we can get a little bit more, but we know $5,000 is on the table and the client wants us to take the $5,000 in the PI case. But I think I could get another, $1,000, $2,000, whatever. I can't change a $5,000 case to a $50,000 case if it's not valued at that. But with that said, are we allowed to advance the client's portion to ease their concern until we work up the remaining portion of the case?
Okay. With respect to loans and clients, even a zero interest loan to a client can very well be a danger for the attorney. This is one of those deals where, no good deed goes unpunished. Even a humanitarian loan of 0% interest to the client, if it does not, because it's still a business transaction with the client, it has to comply strictly with all of the rules. Meaning, obviously, fair and reasonable. Zero interest is certainly that. They have to have the right and time to go get independent counsel. And also, you could never condition a loan to the client on the results of the case. So it has to be a no recourse, meaning it doesn't matter win or lose, you owe me the money. Does that make sense? Otherwise, it's already going to be a problem.
Right, but with regards to advancing client funds versus a loan.
It's a loan because you can't advance something you don't have. It's from your money, not anyone else's money.
Right, but you know it's coming in from the carrier.
It hasn't yet. It's a loan.
So it's still categorized as a loan.
There's a really, for the attorney's viewpoint, a very unfortunate case. And that's why I said, I mean, the case was a situation where a desperate client needed money. The attorney, having pity on the client, lent her money. The attorney settled the case. The attorney wanted to take just her loan back dollar for dollar, no interest. But because it didn't strictly comply with the rules for a business transaction with the lawyer, guess what? The lawyer had discipline in that case.
Wow. And is that business transaction a code or statute or a provision? Do you know it off the top of your head with what the rule number is, or where we can look it up?
It's in the one series.
Okay.
I have to look at it.
Perfect. Again, thank you everybody for joining in. I have Erin Joyce. She's a former state bar prosecutor, currently defending attorneys and providing ethics consultation. Thank you for your questions. I see a lot of attorneys that have joined us, so go ahead and ask us questions. This is your time. Not to say you can't reach out to Erin at any time, but definitely ask us questions. We're talking about, we went over the legal match case, we went over virtual offices, what protections you should have, and we talked about what the new wave of potential liability on attorneys can be. I know we were talking about the state of emergency and client expectations versus desperation, but because the courts are closed and there is a toll on statute of limitations, regarding the topic of the fact that, you know, we do settle cases or we follow clients' instructions because they are the owner and holder of the case, we decide to do what they say. And here we are 2 years out, 3 years out. What is the statute of limitations with regards to civil cases against attorneys versus when the state bar can come after us?
Okay. For a legal malpractice case, it's 1 year. Okay. It's 1 year, except for now it's complicated by there's 90 days after the state of emergency has been lifted by the governor. So that's going to be an issue. But the state bar to look into potential maternity misconduct, they can reach back 5 years. And even that, they can go back further if it's a situation where there's any concealment, or it's 5 years from when the client discovered it. Whatever
What's
happened.
the longest you've seen records being pulled or asked from an attorney in your experience?
There have been prosecutions of misconduct that happened like 11 or 12 years before the investigation started.
Oh, wow. So it could go back and you never know. So with regards to that, the client could come back within a year regarding civil, but or whether or not whenever the state of emergency is lifted, and then state bar for 5 years.
That's why it's really important to have everything documented with your client, because you and I remember, or if I had to deal with my client, we discussed it. Memories fade over time. That's why if it was worth a phone call, it's worth a quick email confirming it, whatever happened. Because then
confirm it with the client is what you're saying.
Yes, I'm not talking about unfriendly. I'm just talking about like just a documenting, hey, you know, client, we said that we discussed this. Let me know if this makes sense, or am I right with my memory of what we talked about? Whatever way you have to put it, I always usually, almost always follow up any communication I have with the client on the phone with an email.
Just a general rule of thumb, follow up with anybody with a written form of communication, email, certified mail, mail it if you have to. That way you can have some proof. We do have a comment. It's from an HR consultant, and she says, the same rule of thumb is for HR, bad idea and potential legal ramifications in providing payroll advances, especially in tough times. So that's good to know, like the finance world and the legal world are kind of on the same basis. Erin, I did have a question. We had a question come in prior to our live that attorneys wanted to know the difference between straight referring of matters to another attorney. For example, I refer a case to you and I don't touch the case. I have nothing to do with the case, versus when you need to have a specific Rule 1.5.1 agreement where both attorneys and the client sign off on it. So starting with the referring attorney, the 200, can you touch upon that? What is it, and what responsibilities or liabilities does the referring attorney have, if any?
Okay, in California, I don't think there are any cases where an attorney has been found liable for a negligent referral. I think there is one case that gets close, and it's an old case, where an ongoing client with that attorney was looking for help with another legal matter, and the attorney said, I will get you someone, and guess what? He didn't. And so there was liability, but that's not the same as a negligent referral at all. So, however, if what it is that I have a client or a potential client and I want to give it to, let's say, send a case to attorney Abel, and I want to get it, and Abel and I come up with a percentage, like I'm going to get 25% of the legal fees from that case when it finally comes through. That kind of referral agreement has to be documented at the time the referral agreement was arranged. Now, under 1.5.1, under 2-200, the former rule, that kind of agreement had to be in writing, but it could be done at the end. But now, to be enforceable, that agreement has to be in writing at the beginning of the case, or not the beginning of the case, at the time of the referral agreement, which probably would be at the beginning of the case. Also, there's a very recent, in the last maybe 3 months, appellate court case, which found it's not merely acquiescence that's necessary from the client. It has to be affirmative agreement. So you have to be really careful in language. And because it has to be, the client needs to know not just that there's a referral arrangement, but the actual way the money's going to be split. If it's a percentage, that you have to actually lay it out what the percentage is going to be to the referring attorney. So in effect, that referral agreement, that 1.5.1 agreement, needs to be in writing, signed by the attorney receiving the referral, the referring attorney, and the client.
Okay, so specifically outline the terms of the referring percentage. Erin Joyce is going to, so it'll probably be like Malyan Law will pay Erin Joyce Law 20% of all attorney's fees collected in matter such and such, date of law such and such, whatever the scope of representation is. So I'll sign it, you'll sign it, and have the client sign and date it.
Yes. Also, you have to put a provision in there, which is carried over from 2-200, which is that the overall attorney's fees will not be increased as a result of the referral.
Right. And we have that language. So if anybody needs that language, please feel to reach out. It's a specific form. You just put it in there. It's a full disclosure. Like Erin said, that it does not tailor or differentiate or cause the attorney's fees to go up just because that there's this split. It comes out of the attorney's fees and not from the client's portion.
Exactly.
So that's great news to know, and that's definitely something to have. But now, with regards to those referring, so whether it's a referral or a Rule 1.5.1 agreement, do you recommend attorneys to pay those fees from their IOTA account, or do you recommend them, or can they pay it from their operating account?
I don't know how they could pay it off their operating account because it's part of that settlement. So when you put settlement check into the IOTA or client trust account, right? Let's say it's $10,000 to make the math easy, and it's a 40% attorney's fees, and the referring attorney is getting 10%. So forget there's any liens. So if it's $10,000 gets deposited, 40% is attorney's fees, so $4,000 is in my IOTA account for attorney's fees. The $6,000 check goes out to the client. So of the $4,000, 10% is going to go to the referring attorney. So out of my IOTA, I'll be writing $400 check to the attorney for whom I owe the referral fee to, and then the $3,600 from my IOTA will go into my operating account. Because you need to trace for each settlement that goes into the trust account, you have to be able to trace every single dollar of it, how it came out.
Perfect. And so just the rule of thumb is always, if it's a settlement agreement or settlement check, to do it from your IOLTA, just like Erin said, to trace it. With regards to, we do have a question. I'm going to come back to the IOLTA account because I do have follow-up questions, but there's an attorney here saying, if an attorney takes pro bono case and wins for the client, what complications arise if the attorney wishes to make, or if the client wishes to make a gift to an attorney thereafter as a thank you? So I know this bleeds into the gift and what type of gift and the value. So can you touch upon that?
Okay. A client can, a gift, like if a client brings you a plate of cookies, obviously no problem. If the client wants to say, what a great job, you just got me $100,000 on my, wrongful eviction case, I want to give you a $5,000 check. That's not attorney's fees. That's a gift. As long as there's no obligation to make that gift, you can accept that. You can't.
So there's no monetary value in accepting a gift?
I mean, as long as there's no contractual obligation to make that quote gift.
So you can't contract the gift. I can't say, Erin, if I win your case, then you're going to buy me a Lamborghini. I can't do that. But nope. Should you choose to buy me a Lamborghini, I can accept it.
That's what I would say. Yes.
I mean, we're exaggerating, folks, so don't take it literal. But the point is that if it's not contracted for, and if it's just a simple gesture of, a thank you or kindness or appreciation, then it is. But once again, you can always call and find out. So do your due diligence before you accept any gifts. Erin, going back into, if anyone has any questions, please let me know. These are great questions. These are practical questions that attorneys are facing. So attorneys out there, or even consumers, clients, ask us any questions you're facing with attorneys. We're both practicing attorneys, and Erin has extensive litigation and state bar experience that she can chime in. Go ahead, Erin. What were you going to say?
I was going to say about the gifts. You can't say, thanks so much. You did such a great job for me, Christina. I'm going to put you in my will, and you're going to be, that's not the kind of gift you can take. Okay. There are certain other obligations when you become someone's beneficiary or trustee. Oh, yeah. But I'm talking about like a gift, a thing, a check.
Right. And there's been those situations because I do estate planning to a limited extent, but being a beneficiary and the attorney for a third party that is not family related, there are huge issues, and there are concerns to have that. Now, going back to the IOLTA account, which I think is huge, and I think maybe from your experience, if you can chime in, IOLTA gets a lot of attorneys in trouble, and it could just be because of simple math. It could be just because, they were off by a penny, but it could trigger something for full-blown accounting and whatnot. But with regards to the IOLTA, we're always under the impression that it's only for clients' money. But I know I've had a discussion with you that it doesn't, and correct me if I'm wrong, that it doesn't only entail clients' money. If there is a fee dispute with regards to fees owed and it's a third party involved, we can keep that money and that draft into our IOLTA account. Is that correct?
Yes. What I would say is this. Under Rule 1.15, it's very clear that the attorney owes the same fiduciary obligation to any third party who has a claim into the entrusted funds as they have to the client. And the classic situation there is if you have a chiropractor who treated on the case and the client, and it's only $10,000 settlement. So $10,000 settlement, 40% attorney's fees. That means there's only $6,000 to cover, a $5,000 chiro lien, and the client wants some money too. So now you have the client that says, I don't think the chiropractor should get $5,000 or of my only $6,000. So there's a dispute between the chiropractor, how much of the lien is should be paid, and the client that wants all of it, or to pay the chiropractor as little as possible. So the entirety of the disputed portion, which is $5,000 of the $6,000, is in dispute. So all the attorney can do is release the undisputed portion, $1,000, to the client. The whole $5,000, which is enough to cover the disputed amount of the lien, which is the whole entirety of the chiropractic lien, has to be remained in trust until you're able to negotiate it with the chiropractor, or you have to go interplead the money.
So question, with regards to keeping it in the trust, can you keep it in the main trust that you have all the other client funds that are being deposited, or should you open up a separate trust account? Or is that with relation to client fee disputes only?
I think the only time you want to be using a separate freestanding like client trust account is when you can only use your IOLTA for when it's going to be a de minimis amount of money, or it's only supposed to be in the account for a very short amount of time. The classic situation is when you're only putting in a settlement draft. Even if it's a large settlement draft, it's not intended to be there very long, right? You're just supposed to be keeping that $100,000 in there until it clears the bank, and then you disperse all $100,000 of it from that account. So a very large settlement check is totally appropriate to put into the IOLTA.
Okay.
But let's imagine you're in a family law case and you're the one that's going to be holding the proceeds from the sale of the community property. We don't have a marital settlement agreement yet. So $100,000, it's not a small amount of money. And you don't know when we're going to settle that dispute over the property division. So that probably, actually not probably, I can guarantee that $100,000 should be in a separate client trust account where the interest is going to inure to the benefit of the clients, not in your IOLTA.
Because the interest in the IOLTA goes to the state bar.
Absolutely, exactly.
And so you carve out that specific account so that the interest is accumulated, doesn't go to the state bar's tax ID and accounting, it goes to the interest of the client, correct?
Well, if it's a family law case, the reason why you're holding it in trust is because it might potentially belong to one of the client, your client, and some part of it may belong to the husband, let's say. Okay. So both people have interest in it.
Erin, we have a question here, a couple of questions, follow-up questions. I think were great questions with regards to, I know we were talking about what we can hold in trust and whatnot, or gifts. Somebody is asking us, because I shared it on our LA Network attorney group as well, so that, you know, attorneys can tune in. Hopefully we can get more questions. But somebody's asking, saying, can an attorney hold money for a client?
Well, yeah, you can hold money for a client, and if you're holding money for a client, it needs to be in a trust account.
In a separate trust account, or can you hold it in the collective trust account?
Again, IOLTAs are for either a limited amount, de minimis amount of money, or you're only going to hold it for a short amount of time. So, client says, "Hey, I want you to ask us as an escrow agent to deposit this, $50,000, which you're going to pay out to the third party once that third party has performed under the contract." You can do that. And if it's only going to be 2-3 months, it's all facts driven. Probably will have to be okay with putting that in your IOLTA. But if it's going to be something you're going to hold that $50,000 for a year till they've fully performed all of something, then maybe in that kind of circumstance, now it's not a small amount of time. It's $50,000. That probably money should be in a
so short term goes in and out of the IOLTA trust account. If it's a long term hold, is there any restrictions on why or when you cannot hold client money? Let's say it's not a family law matter. Let's say I come to you and I say, Erin, here's $100,000. Please just put it into a client trust account. I need you to hold this money. Is an attorney allowed to do that?
You have to have a legitimate reason as part of your practice to be holding the money. You can't be engaging in money laundering.
Okay. So that's number one. There's a follow-up question to that the same person asked, is saying, if the other person owes money to your client and the client wants the attorney to hold in their IOLTA account, can the attorney do that? I think you touched upon this.
Okay. Attorneys sometimes are asked to act as escrow agents. There's a business like let's say a construction project or some kind of project that has different phases that need to be completed. And instead of progress payments being directly made to the, let's say one of the parties, the money is going to be deposited with an attorney to be doled out as, performance is underway. So that's not improper. An attorney can act in that circumstance, and they're having legal fees for doing that work. But I would say I have seen situations where attorneys have acted as escrow agents and they ended up holding the bag when things blew up. because remember, you have the same obligation once you put that money into your trust account, not just to the client, but to the third party.
Correct, because you're acting as escrow and you're supposed to be a neutral party. I think that there's a follow-up that says, if you know, Erin, if not, we'll direct the person, whoever knows this answer. Same question. How do you, same person, how do you open a separate trust account for a probate matter?
You have to go to, I mean, I don't know indirectly, but I'm sure, I think you can get a court order from the probate court, and that's not usually the attorney that does that, it's the trustee.
Yeah. So I'm not sure either, but to open up a separate bank account it's not an IOTA account. It's not the interest-bearing account for the state bar purpose, but there are other type of interest-bearing accounts that you can open up for the client's interest and act as escrow, like Erin said. So, so we went over the IOTA, Erin. We went to paying, anything that comes, anything that is going to be split between attorneys should come out of your IOTA account. Do not commingle it. Now, there's one interesting matter, Erin, and I've, had several debates with other attorneys with regards to in a personal injury case. Sometimes we get our medical payment coverage funds prior to our third-party settlements. And I know there's a difference between pulling that money before settling the case or the third-party case. Now, there's this concept called when your interest becomes fixed. What is an attorney's responsibility when they know their interest has become fixed? What are they supposed to do? And the example I'm going to give is when I get a medical payment check, for example, for the full amount, $5,000. In California, most, if not all, medical payment coverages are all reimbursable unless we negotiate or get them waived. But we are responsible to pay that back. So I am informed, or I believe that I need to take out my attorney's fees at the moment that I know it's fixed at a reasonable time. Can you please chime into that?
Well, any money that's deposited into your trust account, once the attorney's interest becomes fixed in any part of that money, the attorney can't leave earned fees in the trust account. If you do, and I actually came across this situation under, I cannot tell you what circumstances right now.
Right.
It certainly was not a bounced check because there were like several $100,000 in this trust account that the attorney could not put as owned by any clients. He was just maintaining a lot of his own money, because he wasn't reconciling his account at all. So it was his money. It was like several $100,000 of his own money in his trust account. That's commingling.
So as an attorney, if I think that the MedPay is going to want their full $5,000 back, and I really don't know, even though I know that they almost always give me my 1/3. For example, can I take out my 1/3 and then if they want the whole thing back, give it back to them? Or should I just leave the $5,000 or whatever amount it is in the trust account until I know that if I have earned those fees, then I can transfer it?
If there's any question, if you have legitimate, colorable basis to claim that you did not know your interest was yet fixed, you can leave it in there.
Okay.
That's fine. But if you can't have settled a case and decide, you know what, I'm just going to keep extra money. I don't need to take it out. You have to regularly, and it's as soon as practicable. So it's not like, oh, I just earned this money that same day. I need to write out a check into my operating account.
Right.
But like monthly basis, when you're reconciling your account monthly, you should be taking earned fees out of your trust account.
Right.
In your situation, it sounds like there is some chance that you may disclaim any interest in the MedPay payment, and depending on how the case shakes out, right?
Right.
So then you can leave it in your trust account. But if you are definitely under your fee agreement taking 1/3 as your the attorney's fees on the MedPay, you also can properly take it out at the time you receive that check and it clears.
Very nice. We have a lot more followers. Thank you so much for everybody joining. I do have Erin Joyce with us. She is a former state bar prosecutor for California Bar, and currently she owns her defense firm protecting and defending attorneys and providing ethics consultation. We have discussed a lot of topics, so if you guys do have time to go back and look at our feed, this is going to be on both of our pages. I've also shared it with the LA Attorney Network. We're getting a lot of questions in. I think I should have shared it sooner, but so we've discussed a lot of matters, whether it's virtual offices, client expectations, state of emergency, tolling of statute of limitations, the legal match issue, IOLTA matters, referring, and split fee agreements. We are going to move on to the topic of malpractice insurance. So, Erin, what is your advice as as one that is on the other side defending attorneys? Should attorneys have malpractice insurance?
I think it's very important for every practitioner to carry errors and omissions insurance. It's to protect you and to protect your clients. It's very, very important to maintain coverage once you have it and not let there be any breaks in coverage, because right. Yes.
Go ahead. What do you mean by that? When you say they're not breaks in coverage, why is that? What's the concern?
Okay, like if you have an auto policy and you have it effective, for 1 year, and then you let your insurance lapse and then you pick up new coverage, it's not the same, because what's going to happen with your errors and omissions, it's not based on like when the accident happens with your auto insurance, right? So as long as I buy coverage today, I'll have coverage for my insurance, for an accident I might get into tomorrow. I'll knock on wood. I'm not going to have to happen. But errors and omissions is claims made as a claims made situation. So if you have a lapse in coverage, it's going to cause a huge spike in your ability to get insured later, because, you know what I'm saying? It's going to be when you're, let's imagine I get insurance now, a claim might rise today based on, something I did 2 or 3 years ago, or not 2, actually 1 year ago, because again, there's only a 1 year statute. So you want to keep continuous coverage with your
1 year statute with regards to when the damage arises, but like estate planning attorneys, probate attorneys, that can be mature in 30, 40 years. We don't know when. That
is actually true.
Yeah.
That's true.
So I kind of came across this issue because it's very important. Like you said, like Erin has been mentioning, having an auto coverage, health coverage. Health is a little different, but I'll just stick to auto, which is what I do in practice. If you have an auto coverage from January 1st, 2020 to December 31st, 2020, assuming that all, ducks are in a row, the I's are dotted and the T's are crossed. If you get into a car accident, the hope is and the goal is that the auto insurance carrier that you have and are insured with will pick up the defense or coverage and pay for the damages. It is not true. It's not the same for malpractice insurance for attorneys. And I can only speak on attorneys' behalf. So the errors or omissions and the coverage is based on the continuity and the longevity of the coverage. So the minute you get coverage, if you ever, if anything arises during that coverage, but then you don't have coverage, they will not pick up the defense, and they will force you to be out of pocket and whatnot. So it's very important. If you have it, continue it. If you don't, there's ways to carve out also. If you've worked from a different firm, I've changed a couple of firms, so I know this from personal experience. There's a way to carve out the retroactive period as the attorney handling it and versus the other partners handling it. But Erin, that brings me to my next question, whether or not if I have if I have malpractice insurance, will my insurance, hire defense attorneys, or can I choose to hire you to defend me, whether or not it's state bar related or client-based related? How does that work, if you know?
I can tell you that Lawyers Mutual, as of April, as a new benefit to their policyholders, has added coverage for disciplinary matters. But as you might imagine, they also don't want to be responsible for who you select as your defense counsel, because they don't want to be somehow responsible for how that's going to go. It's not quite the same as when you have a legal malpractice case, and and even in those cases, they're usually eroding policies. And so whatever amount of coverage, part of it, if you keep, as the more you defend it, the less money there can be to pay any judgment or settlement. But in a disciplinary case, I think they just will cover up to, I think, $50,000 of defense costs, but you get to select your own respondents counsel.
Okay. Have you heard the term of burning policy?
Yes, that's what I'm saying. It's an eroding policy.
Okay.
Yes.
Go ahead.
So basically what happens is, let's imagine I have $500,000 of coverage for, I'm just making this up.
Mm-hmm.
And in those kind of situations, normally, and this is true with almost all type of insurance, the carrier gets to determine who the defense counsel is going to be. And as the case is being litigated, but the client attorney has, and just like this is also true in medical cases and for errors of omissions, right. The doctor or the attorney has a right to determine whether or not, because in an auto case, State Farm can settle the case even if you were not at fault in the accident and you want a trial. They don't care. They're going to settle it.
Yeah.
Not the way these cases work. It's like you can, like, your honor is at stake, so you can force this case closer and closer to trial. But the punchline is, the more and more money is spent on the defense of this case, there's less and less likely to pay, left to pay either a judgment or to settle the case. So that $500,000 keeps eroding down or burning down as month after month that defense firm is billing on the defense of your legal malpractice case.
Got it. Very nice. Thank you so much for that. Let me see if we have any more questions, because I want to end with the last question that's come in, which is, can you be a partner of two law firms at the same time? And I know you touched upon this earlier when you said regarding trade names, and it's very state specific, and the constitutional, without getting into the constitutionality of it, can an attorney be an owner of two law firms?
I think I did some research on a similar issue, which is that, can an attorney be a partner in two different law firms? And having looked at, the state of law across the country, I found a lot of cases where, yes, as long as there's no either misuse of the name or something that causes consumer confusion, an attorney can be a partner in two different law firms. So I think by extension, an attorney can have two different law firms operating at the same time, if that makes sense, maybe two different practice areas, as long as there's no it's something that would be confusing to the public.
Deceiving, confusing. Yeah. Like you said earlier in the beginning of our program, it's all about public protection. So just make it very clear. Be crystal clear. Don't hide behind the ball, whether it's your advertisement, whether it's your posts, whether it's the 2 or 3 or 4 or 5 law firms you can manage by yourself or with a team. It's all about the consumer protection. And as long as it's not deceiving, it can't be misconstrued. I think that's the importance of the message here today with Erin, that these are the protections that are available for us, for all of us as attorneys, for our clients to know and not know. And that, if we could stay away from the state bar, that's the number one goal. I know it's very stressful what we do, and it's very hard. Any closing thoughts, Erin, that you came across within the last 24 hours since we spoke?
What would I say? I mean, I would say we're in a times of like the interesting times. It's the quasi old Chinese curse. May we live in interesting times, and we certainly are. But these are also times of great disruption, uncertainty, but opportunity. So I think focusing on, we have an opportunity to really embrace technology and innovation that will propel us forward, and that's what I'm trying to focus on and take from a silver lining from this pandemic.
Very nice. Well, I hope everybody's enjoyed this conversation. Erin, where can people find out about you or reach you at?
Erin at erinjoycelaw.com. So it's ERIN at ERINJOYCE law.com. You can email me, or you can just Google me and you can get to me through my website.
Perfect. Your website is erinjoycelaw.com?
Yes.
Okay, perfect. So I'll go ahead and provide all that information as soon as the feed is done. That way they can reach out to you. I will convert everything, for our audience. It was truly a pleasure having you, and thank you so much for taking the time and providing us with decades of insiders knowledge, and we definitely are so thankful to have individuals and attorneys like you who are there to help us and protect us, and be literally for myself, be a phone call away just to reach out to you and be able to have that peace of mind. So with that said, thank you so much. We're getting thank yous on our Facebook Live too. Thank you, Ms. Valerian, for joining in as well. Thank you all. Be safe. I know things are opening up as of tomorrow or over the weekend. Please be safe and stay well and stay healthy. Have a good night.
Thank you.